Your team misses the delivery date by 3 days. Can the contracting officer default you tomorrow? It depends on which ground they use, whether the government sent the right notice at the right time, and whether the government waived its rights along the way. Today, I'll map 3 default grounds in FAR 52.249-8 in A1 and A2 and explain how anticipatory repudiation fits with cure and show cause under FAR 59.607B, and we'll finish with the DeVito waiver doctrine that can rescue or sink a termination.
Welcome to Claims and Sustains, and welcome back to our series on government contract terminations. I'm Teddy Arnold. With me is Zach Jacobson. In episode 1, we framed the landscape on terminations for default. Today, it's all about entitlement. When is a T for D justified on the merits and procedurally clean? We're going to keep our anchors in the relevant clause, 52.249-8, and discuss a couple of practical doctrines, including the common law anticipatory repudiation and the DeVito waiver doctrine.
So think of FAR 52.249-8 as having 2 doors. Door number 1, under A1, that's the late delivery door, or late is late rule. That simply means that if you miss the delivery date or your completion date, and you don't have any excusable delay, and we'll come back to that later, the government may default terminate you immediately with written notice. There is no cure requirement for a pure schedule miss. The delivery date includes any properly executed extensions or bilateral mods. So a good tip for contractors, keep the paper trail on any extensions that the government has given you or any government-caused delays that have occurred during performance if that will push your path to the right. So why the government doesn't always pull the trigger on day 1 when it comes for termination for default is this. A T for D will pause the mission while the agency goes out and reprocures. It's faster sometimes from the agency's perspective to allow the contractor to finish and to use liquidated damages or some other contract remedy instead. FAR 49.402-4 even lists many alternatives to default, such as revised schedule, bring in a surety, allow a sub to perform, or to terminate for convenience instead. Now, door number 2, A2, failure to make progress or other material provisions. This is where termination for default gets a little more complicated. Everything other than being late lives here, and it requires notice and a chance for the contractor to cure. So 2 frequent A2 buckets. 1, failure to make progress so as to endanger performance. So think of like you're slipping the critical path. You have cash flow crises. You've missed a first article milestone. The other is failure to perform any other material provision. This is everything else. It's serious spec defects, integrity breaches, or first article failure. So under A2, the contracting officer must issue a written cure notice to the contractor and provide the contractor at least 10 days to fix the noted deficiency. If time is too tight or the date is passed, the government can issue a show cause notice. Now, both of these notices are referenced in the FAR under FAR 49.607B. The government's case improves dramatically when it papers the file with a clear notice, response windows, and objective evidence of the contractor's failure to perform.
All right, so let's talk about excusable causes and subcontractors, right? So even for A1, the government cannot default for failures beyond the contractor's control and without its fault or negligence. Classic force majeure events like fires, floods, epidemics, pandemics, strikes, unusually severe weather. If a sub was the problem, the default is excused only if the cause was beyond the control of both the prime and the sub, and the prime couldn't reasonably obtain the supplies and services elsewhere in time. So keep contemporaneous documentation, weather logs, supply chain records, union notices, what the government can take and must pay for. Let's talk about that. Upon default, the government may require transfer of completed and partially completed supplies, manufacturing materials, tools, jigs, dies, drawings, stuff like that, assets that essentially help a follow-on contractor sprint to the finish. The government shall pay the contract price for completed supplies delivered and accepted, but the work in progress, that stuff that was ongoing, is a risk zone for supply contractors in particular, which we talked about in episode 1. Let's talk about what happens if the government is wrong. A procedurally or substantively improper T for D converts to a termination for convenience, a T for C. The contractor then recovers its incurred costs, an allowance for reasonable profit, and its settlement costs. But no expectation damages. In other words, no profit that it was expected to earn had it eventually ultimately completed the contract. So let's add the common law overlay, anticipatory repudiation. So even though the clause doesn't spell it out, the boards and the courts recognize that if a contractor makes a clear, absolute, and unequivocal statement or takes some kind of unmistakable action showing it will not perform the contract, the government doesn't need to wait for the due date to default. So classic examples of this are a contractor pulls all of its crews and key equipment off the project. A formal notice that the company is stopping work or lacks the capacity to continue, a refusal to buy required long lead materials when the timeline otherwise demands it. So retraction matters. If the contractor retracts the repudiation before the default is issued, in other words, it mobilizes its crews again, or reinstates purchase orders, or otherwise commits to timely performance, the anticipatory repudiation basis essentially evaporates. So timing really is everything in this world. So don't mislabel the scope fight as an anticipatory repudiation. In other words, if the contractor pauses because it believes the government ordered a cardinal change, something that's way outside the scope of the contract, that's a disputes issue, not a repudiation. So miscasting a scope dispute as a repudiation is a common path to a termination for convenience later on.
Now waiver, often called the DeVito doctrine. The government can lose its A1 late is late right if two things happen. First, if the government unreasonably delays acting after the deadline passes, and second, the contractor relies on that delay, and by continuing performance with the government's knowledge or consent. Think if the agency urges weekend work, approves overtime, or accepts interim steps. These facts create an equitable waiver for the immediate default right. So what's the government playbook to avoid a waiver? Well, the government should send interim notices immediately after the miss. Something along the lines of, we're considering default, do not incur additional costs. Using a show cause notice if the date is passed or if fewer than 10 days remain, or using a cure notice if there's time for a 10-day fix. So if the government decides to give the contractor a second chance, the government could issue a bilateral modification, issuing a new start date and a new delivery date, and that can become the new A1 yardstick for future potential defaults. Now, be careful with government conduct. Don't spur performance for the contractor by saying things like add crews or speed up or oh, we'll accept on Tuesday instead while you're still deciding default. That fuels the contractor's reliance case against the government and can defeat a termination for default. The government should also keep the record clean. Document deliberations under the FAR 49, 402-3 and 4. These are the termination for default factors and alternatives considered, and articulate the best interest rationales. Now, the contractor has some countermoves here as well. If the government stays silent while the contractor keeps performing, or better yet, encourages the contractor to keep performing, the contractor should preserve those emails and all of those meeting notes. That is the contractor's DeVito file. Also consider proposing a new realistic date via bilateral modification, because if the government signs it, you've essentially reset the clock.
So entitlement's all about timing, notice, and evidence. Under A1, that's late as late. If you're a contractor, you're going to be looking for excusable causes that apply, or whether the government has waived by delay and encouragement. Or alternatively, under A2, you must see written notice in a cure window or a show cause when time is short. We're talking about anticipatory repudiation that demands clear, absolute, unequivocal facts. Even then, many contracting officers may still send a notice to protect the record. If the government blunders, expect conversion to a termination for convenience with cost, profit allowance, and a settlement cost. But again, no expectation damages. Next time, we're going to talk about dollars. We're going to unpack excess reprocurement costs under 52249-8B and liquidated damages. Plus, discuss the Fulford doctrine, which lets contractors focus on the legal fight on money, even if they didn't immediately appeal the default. And that's all from Claims and Sustains. We'll see you next time.